Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. Before adverting to the rival contentions of the parties raised before us, we may notice that the purported pledge of jewelry was made by the respondent herein for taking a loan of rupees 7,000. Stop. Appellant indisputably is a moneylender. Stop. A criminal case for charging excess interest was instituted against him on 29/3/1997. Stop. Para. Respondent thereafter served a notice upon the appellant asking him to return the pledged jewelry. Stop. As neither the said notice was replied to nor the jewelry was returned, he filed the suit on 26/6/1998. Stop. Para. The cause of action for filing the suit was stated in the plaint, which reads as under : Para. The plaintiff, through counsel, sent registered notice dated 12/5/1998 and demanded the pledged jewels. Stop. Still, the defendant has not returned the jewels of the plaintiff. Stop. Therefore, this suit is being preferred. Stop. Para. Respondent examined himself as a witness in the suit. Stop. He stated that the appellant being his cousin brother, no document was executed. Stop. He also testified that in the criminal case, appellant having admitted his crime and pledge of jewelry with him. Stop. Para. Indisputably, the judgment in the criminal case was marked as an exhibit. Stop. Appellant also, in his deposition, stated that it is correct that plaintiff filed a complaint against him before police and case was registered. Stop. It is also correct that he confessed upon advice from his advocate. Stop. Para. He admitted that even one person had borrowed money from him. Stop. It was furthermore admitted by him that he received the notice from the plaintiff, but he had not replied thereto. Stop. Indisputably, the law relating to the admissibility of a judgment in a criminal proceeding vis-a-vis the civil proceeding and vice versa is governed by the provisions of the Indian Evidence Act. Stop. Para. The learned counsel for the contesting respondent suggested that it had not been found by the lower appellate court as a fact upon the evidence adduced in this case that Girish was the nearest agnate of the testator, or that Charu had murdered his adoptive father, though these matters had been assumed as facts. Stop. The courts below have referred to good and reliable evidence in support of the finding that Girish was the nearest reversioner to the estate of the testator. Stop. If the will is a valid and genuine will, there is intestacy in respect of the interest created in favor of Charu if he was the murderer of the testator. Stop. On this question, the courts below have assumed, on the basis of the judgment of conviction and sentence passed by the High Court in the Sessions trial, that Charu was the murderer. Stop. Though that judgment is relevant only to show that there was such a trial, resulting in the conviction and sentence of Charu to transportation for life, it is not evidence of the fact that Charu was the murderer. Stop. That question has to be decided on evidence. Stop. Para. It was held that even at the outset, I want to state that the view of the lower appellate court that the plaintiff has not established satisfactorily that the first defendant or the second defendant or both were responsible for the theft is perverse and clearly against the evidence and the legal position. Stop. The lower appellate court refused to rely on Exhibit A3, which is a certified copy of the judgment. Stop. it is true that the evidence discussed in that judgment and the fact that the first defendant had confessed his guilt in his statement is not admissible in evidence in the suit. Stop. But it is not correct to state that even the factum that the first and the second defendants were charged under sections 454 and 380 IPC and they were convicted on those charges could not be admitted. Stop.